go. So the rights are generally internationalized, and there are similar standards everywhere in the world. Again, like I mentioned earlier, intellectual property covers copyright. And when we talk of copyright, we're looking at literary, artistic, scientific works, performances of artists, phonograms, broadcast, scientific discoveries. And I mean, there is also the field of patent, which basically deals with inventions. Then we have industrial designs, which cover visual features of products. Then trademarks regulate the way marks are used to distinguish goods and services in the course of trade. When we go, I think I'll probably start with copyright. Copyright covers literary works. One common misconception, interestingly, about copyright is that a lot of people actually feel that it's a right that you have to register for you to enjoy its benefit. Copyright subsists automatically once a work is created. Copyright exists in that work, and the threshold for copyright protection is relatively low. It's essentially that the work emanates from the author. So it's not required that the work is of a particularly significant quality, or it's not required that it should be of a particular academic merit. All that is required is actually that it originates from the author. So it's an original work of the author. And there is a practice which a lot of lawyers would be familiar with in Nigeria, for instance, whereby clients are encouraged to register their rights with the Nigerian Copyright Commission. Now, there are people who are under the erroneous impression that you get your copyright by that registration. The fact is that the copyright arises automatically once the work is created. The registration process is nothing other than, I think it's substantially a revenue generation strategy for the commission, and of course for lawyers who also help clients to register such works. And it also serves some record keeping purposes because it's stored in the database of the commission. So it's not like there is no benefit whatsoever to the process. So it serves as a record with the commission, but it doesn't in any way guarantee that the work is even original. It doesn't mean that the work that has been registered could not be an infringing work. It doesn't mean that work might not actually be an infringement of another copyright. So copyright exists automatically. It arises by operation of the law once a work is created. Now, the thing is, you do not have to publish a work to actually have copyright in the work. Once the work is created and you can show that it is an original work emanating from the author, even if it is unpublished, there is copyright in it. Another interesting thing about copyright that a lot of us may not be familiar with is it covers things from the letters you write to the notes you form. Let's say, for instance, in the course of this presentation today, you are making notes and forming your own notes based on what the speakers are saying, but you are essentially summarizing their points in your own words and not just reporting them verbatim. You have copyright in the note you are actually forming. As a matter of fact, you even have copyright in recording speeches made verbatim that were not written down or recorded. So if for instance, you interview someone and they gave you a report verbatim and you reported it and wrote it down, the copyright in what you have written is not in the person that granted the interview, but in the person who actually took the interview and wrote it down. So when journalists interview people, essentially, the journalists own copyright in the result of the interview. So there is a distinction as well between the property rights in a work and the copyright in the work. You can own a book, which means essentially it is your property, but the copyright in the book belongs to the author. So your right to deal with the book, and that is why if you are photocopying that book, you are actually infringing on copyright. Even though it is your book, you do not have the copyright in the book. So the intellectual property of the author in that book subsists, even though the property itself is yours. The copyright or intellectual property in it belongs to someone else. And a whole lot of authorities can be found in this area. I think because of the time I have, I just have to be as brief as possible on a lot of these principles. What I will be doing will be to present a general overview. I hope I will be able to cover all the aspects, at least basic overview of all the different types of intellectual property. And then Professor Shodipo Essien would be able to come in and expand some of those issues a little bit further, and also discuss the opportunities and benefits for practitioners in the field. So again, copyright covers works that have been reduced into a permanent form. So if you have an idea, let's say, for instance, you share a story with someone, and you, as you share that story with them, they actually wrote it down, and they made a success of that story by maybe turning it into a book or even turn it into a film script. Who owns the copyright in the work? The person that actually gave the story, or the person that turned it into a book? The copyright belongs to the guy that actually turned it to a book, the person that reduced it into a permanent form. So when people, the bottom line of that is copyright does not subsist in ideas. It does not subsist in ideas. So you cannot claim copyright for ideas. You can say, well, that's my idea, I have copyright in it. No, you do not have copyright in ideas. If you share your ideas with people and they take advantage of those ideas and they turn it into a permanent form, they own the copyright. You can't even claim any form of copyright infringement. But that doesn't mean you do not have any intellectual property remedy at all. What someone can do, what the owner of the idea can do in that situation, is to rely on the law of confidential information, which is also a form of intellectual property, interestingly. But of course, it's a thought that is not so easy to establish, which again is why people should be very careful when they share ideas that they consider valuable to them and that are of significant economic value. Again, I think I will go into confidential information later. I would quickly complete the part on copyright so that we can move to other things. So essentially, there is another form of protection that may exist in such a case. Now, a few points to note about copyright is essentially it subsists for up to, especially for literary works, it subsists for up to 70 years after the death of the author. So the entirety of the life of the author, it subsists for the period of existence of the authors, the life of the author plus 70 years thereafter. Generally, copyright requires that the work is substantially original, which means it's substantially emanate. I mean, it's substantially emanate from the author, and there will be no copyright infringement if there is insubstantial copying. Now, this might be another tricky point. So if, for instance, in a 12, let's say 40-page book, it was found that half a page contained things that were copied from another source, would that mean the entire book is in breach of copyright? Would you be able to succeed in an action for copyright infringement for some sort of insubstantial copying from another work? The answer is no. If there is an insubstantial copy, then you cannot establish copyright infringement. So the copy has to be a bit substantial for you to establish copyright infringement. Now, like I said, this is a tricky point. How do you determine what is substantial and what is insubstantial? It's not so clear-cut. In determining that, the authorities actually say that you need to look at both the quality and quantity of what has been copied. So it is not sufficient to say that, well, what was copied was actually just a little quantity. If it's a little quantity, but it is of very significant quality, it would be considered as substantial copying. So insubstantial basically means that in terms of quantity and quality, it's insubstantial. Now, if again you have a very substantial, in terms of if you have a lot of stuffs that were copied from a different source, and you think that is enough to be substantial, the court will still look at the quality of what has been copied. So it's possible to actually take things that are of high quantity but very low quality. That would be considered insubstantial. And in some cases, there are things that are even not protected by copyright. For instance, if you put down the list of states and capitals and the cities and towns in Nigeria, and you put that in a book and you say you have copyright in it, you can have copyright in the organization structure and the formatting of the process of the work, but the content is basically nothing protected by copyright. There is no copyright in the names of cities, places, towns, and states and capital. So that wouldn't be that wouldn't be protected by copyright. And if someone copied that content, even though it could be a lot of quantity, the quality is nothing. It's really nothing. So essentially, there is no copyright infringement in that. So these are some of the nuances about copyright law. It covers broadcast. The protection for broadcast is generally for up to 50 years, sound recordings, films. And another point I will quickly mention about copyright is that adapted works create another sort of dilemma for people who deal with copyright. Now, I remember there was a case that arose, and I think it's still in court, over the movie made by one of the very famous Nigerian actresses. I think it's titled Dry. I can't remember the name of this particular lady. She was also a beauty pageant, probably former Miss Nigerian. I can't remember her name anyway. So she made a movie. The title of the movie is Dry. And there is a graduate of Obafemi Awolowo University that actually claimed that the movie was an adaptation of a book that graduate wrote. So they claim that the actress took the story from their book, and the matter is still in court the last time I checked. Now, the argument in the press, of course, I didn't see the court document, but the argument of the actress in the press was that Fame was duly registered with all the necessary agencies in Nigeria, and she had copyrights in her work. Very beautiful argument. Indeed, copyright would exist in the work. There's no doubt about that. And she would have that copyright as the producer. But that doesn't mean if the allegation of adaptation is true, she didn't infringe on the original work in the book. So adapted works actually have their own right. If for instance, adaptation can be in different form. Let's say Chinua Achebe's Things Fall Apart, it has been translated into different languages. So if you decide to translate Chinua Achebe from English to Igbo language, for instance, the translator, the person who translated it would have copyright in the adaptation, which would be the new work coming as an Igbo translation. But if that person took that liberty without getting the consent of the owner of the work, the whoever owns the copyright after Chinua Achebe's death, if they don't have the consent of the family to make that adaptation and translation, they would be infringing on the original work, and they can be liable for damages for that infringement, even though they now have a new work with their own copyright, which is the adapted work. So it could be adaptation to a film, adaptation to a different language, adaptation to performance. Every adaptation must be based on a license from the original author or copyright owner for that adaptation to actually not be an infringing work. But the adaptation itself would actually have its own right. Now, I'll move on from copyright to trademarks. Trademarks, like I mentioned earlier, are used to distinguish goods and services in the course of trade. There is a similarity between trademarks and passing off. With passing off, you are essentially imitating another brand. With trademark, you are using a mark very similar to a registered mark in such a way that consumers are likely to be confused or deceived as to the source of the product. And it is used to protect the interest of people who have established a brand, who have created a mark that they use to distinguish their goods and to protect their commercial interest as well. Now, there are a few differences between passing off and trademarks. Trademark will only protect exactly the mark that has been registered, whereas with passing off, it protects everything relating to the brand, from packaging to get up to essentially the whole framework of the brand. So any similarity with the brand can come under passing off. However, trademark will only protect exactly the mark that has been registered. Now, the challenge in not having a trademark and trying to rely on passing off is, for you to succeed in an action for passing off, you need to show that you have a reputation, you are well known, you are popular, famous in the market, consumers know you, and you have a well-established brand with a reputation in that jurisdiction. Now, if you cannot establish reputation and goodwill, your case in passing off would fail. Whereas with trademark, the moment the mark is registered, you are protected. You do not have to be known. Your brand does not have to be famous. As long as you have registered your trademark, the protection arises from the moment of the grant of the trademark. Then with patents, like I mentioned earlier, it protects inventions that are new, novel, that possess an inventive step, and that are capable of industrial application. Now, when we say novelty, essentially it means that it is an invention that is not already well known to people with common general knowledge in the field. It's not an invention that everyone in the field or with a basic common knowledge of the field will know. Now, novelty is the test for novelty is not the standard of an exceptionally gifted, talented, or ingenious expert in the field. It is the threshold is the standard of the person with the common general knowledge, with a good knowledge of the field, but not necessarily someone who is extremely talented that actually knows more than what is commonly known by people with expertise in the field. And inventive step means that that new invention is not something that is already obvious, that is already known from what others have done in the field. So if it is something that flows so inexorably from what is already all over the place, then it wouldn't meet the inventive step requirement. So inventiveness is actually meant to put a higher level of requirement to ensure that. So you need to show not only that it is new, but that it is new in a way that is not obvious to people with common general knowledge in the field. It has an inventive step that is beyond what people with common knowledge would easily infer from what is already in the field. And then it is required to be capable of industrial application. When we say industrial application, it doesn't mean that it must be a commercial success. It only means that it can perform the purpose for which it is designed. And now there is a difference between copyright, patents, and trademarks. With copyright, you can take the ideas of a book. As long as you have not copied a book verbatim, you have not infringed copyright. So you can actually look at a book, you've seen an interesting point, or you've still seen an interesting story, and decide to write a similar story in a different language. I mean, you write another story using the same storyline essentially, but in new words. You wouldn't be infringing copyright in a book. Now, if it is actually a movie and you take the storyline, that would be the moment you take the storyline from a movie to act another movie, that's copyright infringement. But if it is a book and you just basically put another story in your own words that is similar to that story, you are not going to be liable for copyright infringement. So copyright protects the exact expression of the work. The moment you change that expression, you are not in breach of copyright anymore. Now, with trademarks, you do not own monopoly over the goods you sell. Let's say you sell bottled water, you can't say others can't sell bottled water. They can do as many bottled water as they want. They are just restricted from using your mark or a mark similar to your mark. Otherwise, they'll be liable for trademark infringement. Now, the interesting thing about patent is it is the strongest form of intellectual property. Trademark can exist for as long as you continue paying your renewal fees. Once you pay your fees to the trademark registry, it can exist perpetually. It is required that you use the mark, which means you use it for trade. You use it on your goods. As long as you use the mark and you pay your renewal fees whenever it is due, then you can have the trademark forever, for as long as you use and pay your fees. With copyright in literary artistic works, essentially life of the author plus 70 years after the author's death. With patent, it's only for 20 years. But the thing about patent is it is the most monopolistic form of intellectual property right, which means that you cannot make a similar product. You cannot make the same product. You cannot even use anything within the patent scope during the period of that protection. When you file for a patent, you actually file a specification, which highlights the specification contains the details of what you are inventing and the scope of your protection. So anything within that specification will be protected, and no one can make any imitation of it. So you have a clear monopoly for up to 20 years, which can be seen by some as anti-competitive, but it is a balance that needs to be struck to ensure that people who invent gain some reward for their investment, and they are also encouraged to share that information with the public by registering the specifications and the patent documents in the patent registry. Now, there is also designs. There are designs rather. Now, with designs protect the visual features of products. The sleek design on a phone, if it is new, can actually be registered. It is required that that design is new, and then you can actually register it. It's the protection offered by design is not the same as patent protection, because it only protects the visual outlook, the visual framework, the visual features of that work. People can make the same work, but they are not allowed to replicate the way the work is designed. So that protection is limited to the visual features of the design. I mentioned earlier that copyright would not protect ideas, but if you have ideas that are of commercial value, you can have them protected by the law on confidential information. Now, the thing with confidential information is you need to show that the information you are actually protecting has the quality of confidence. You need to clearly identify the information that is being brought under confidential information protection. You need to show that it has the quality of confidence and that it was communicated in circumstances involving an obligation of confidence. So you can actually show that you imposed an obligation of confidence on the receiving party or the recipient by showing that you told them that the information was shared in confidence, and then you need to show that it's actually used without your authorization. Now, proving confidential information can be really challenging in practice, and that is why lawyers are often advised to have non-disclosure agreement and to sign confidentiality or include confidentiality clauses in agreement or negotiations or transactions that involve sharing ideas that are of commercial value. If you are pitching an idea to investors and you don't want them to steal your idea, and after listening to you, they refuse to fund you to invest in your business, but they've taken your idea, and it happens a lot, and they go to do exactly what you were planning to do because they have the money that you do not have. So what people do when they want to pitch ideas to potential investors is to get the investors or whoever is listening to them to sign a confidentiality agreement, a non-disclosure agreement, or NDAs are very popular in commercial practice, non-disclosure agreements. If you have a contract, you are employing people to work for you in environments where they would actually have access to confidential information that you do not want them to use outside of the employment, a confidentiality agreement is required. And generally, I think every employer should actually have an intellectual property clause in their employment agreement, because there is no way you work in any organization that intellectual property rights will not be generated in that work. You may not really think that is so straightforward, but it is. Every email you send, there is intellectual property in it. When you compose an email, you have intellectual property in that email, as a matter of fact. So, of course, again, there are limitations to all of these rights, which time will not allow us to explore. Like in relation to confidential information, for instance, there is a difference between defamation and confidential information, and there are cases that have gone to court on that. So you cannot say that, okay, there is a particular case where it's an English case where a duchess who had committed adultery, the story was to be published in the media, and an action was brought to restrain the publication on the basis of confidentiality. And the argument was made that, well, they were just saying the truth and adultery was committed. So why would you stop us from publishing the truth? Yes, you cannot be made liable for saying the truth in the law of defamation. The fact that it is true is a complete defense. It's the justification defense in the law of defamation. But the fact that it is true does not still take away the confidentiality where confidential information is involved. So if information is emotionally damaging and there is no public interest justifying its publication of such information can be restrained under the law of confidential information. And the fact that you are trying to say the truth does not excuse that. Confidential information is a form of privacy law, but it's based on common law. It's not statutory. Now, there are jurisdictions that have, of course, made that a statutory right, but without the statutory framework, you can still rely on the common law confidential information. I've been told that my time is up, and I think I will stop at this point and take whatever questions forwarded to me, and the learned sake would definitely be able to do more justice to the topic as well. Thank you.
Thank you very much, sir, for a very insightful session. We enjoyed every part of the presentation. Professor Olasupowe has given us a background to the types of intellectual property that we have. Thank you very much, our participants, for listening. I know we have lots of questions now, but we want us to wait till the end of the session. After the presentation of Professor Bankole Sodipo, Senior Advocate of Nigeria, we would have time for questions and answers so that we can all have everything together. Thank you very much, sir. Professor Oweye, we hope that you would still stay on the call because we know that people would have questions and questions for you, sir. Thank you very much, sir.
So thank you very much. I'm here, of course.
Thank you, sir. Going forward, I would quickly take the summarized profile of Professor Bankole Sodipo, Senior Advocate of Nigeria. Thereafter, we would have his presentation. Professor Bankole Sodipo is a senior partner at, before I go on with reading the summarized profile of Professor Bankole Sodipo, we recognize the presence of Mr. Olushinwa Bimbola, Senior Advocate of Nigeria, who has been on this call since we started. Thank you very much, sir. We also recognize the presence of our seniors here present. Thank you very much for joining in. Thank you so much. So going forward, I will take the summarized profile of Professor Bankole Sodipo, Senior Advocate of Nigeria. Professor Bankole Sodipo, Senior Advocate of Nigeria, is a senior partner at G.O. Sodipo & Co. He was called to the Nigerian bar in 1986. He received his LLM degree from the University of Lagos while in legal practice at Chief G.O. Sodipo & Co. and his PhD in law from Queen Mary and Westfield College, University of Lagos in 1995. He is a specialist in intellectual property, technology, communications, and allied rights, especially in dealing with regulators on a wide variety of sectors. He is a professor at the School of Law and Security Studies, Babcock University, where he has served as a former head of department and former dean of law. Professor Bankole Sodipo, Senior Advocate of Nigeria, you now have the floor for your presentation, sir. You have 30 minutes, sir. Thank you very much, sir. You can unmute yourself, sir.
Thank you very much, Messi Abudu. First, I want to thank the chair of me. I want to thank the chair of the committee on CLE of the MBA, and I hope that the next 30 minutes and the interaction that will follow with myself and Professor Owoye will make significant impact on you and your practice. First, I also want, secondly, I want to thank Professor Owoye for his kind words. Thank you so much for your kindness. There is a lot that we need to do to grow and expand the frontiers of the bar. Professor Owoye has done so much internationally, and he's placed Nigeria on the map, and we're ever so proud of him. Thank you so much.
Thank you, sir.
To my question, my paper, I don't know whether I have the facility to share screen. Okay, yeah, I think no, they said I've been disabled from sharing screen. But I sent some slides to Dr. Abimbola, and she said she'll send them to Ms. Abudu. I don't know whether she has done that. Please mute. Okay. So they said I cannot share screen. Can my screens be put off by Miss Abudu?
Sir, you can now share your screen. Please check
It's
now.
still saying I cannot, but I'll try. It's still saying I cannot, but I'll try again. Okay, good. Brilliant. Which one is it? Yeah, this one, I think. Right. Can you see my screen?
It's loading. Okay.
Yes, we can see your screen, sir.
Beautiful.
Yes, we can see it.
Right. So thank Professor Owoye once again for giving the outline of IP law, rights and allied rights. So I'll be just alluding to that briefly, particularly on which ones need registration and may not need registration. The reason is that if we want to know what our role should be, and you want to play a role, it's good to know what the law is. Then we'll try to identify stakeholders. Who are the people the law is aimed at protecting, and who are the people that the law is directed at, who may benefit from this law? Because once you know them and identify them, then you may want to make yourself relevant and known to them to offer your services. So what is the role of lawyers as advisors, as counsel to users, to owners of IP? Role of lawyers as owners or co-owners of IP-related businesses. Then end by making some remarks about also building an IP practice, because it's one thing to know the law, is another thing to have clients that we can serve. Like I said, the learned Professor Owoye has shared with us different kinds of IP rights: copyright, trademarks, designs, patents, plant variety, and confidential information, trade secrets, and traditional knowledge. Copyright, which protects literary, artistic, musical works, sound recordings, films, and broadcasts, does not require registration, like we said. Trademarks, which protects brands, logos, get up, and so on, has registration system of registration, and also has a system where you do not need to register. New shapes of based on a drawing of a mold. I mean, the product, maybe it could be chairs, it could be equipment, textiles, electrical circuits. They must be registered, or otherwise no protection. Patents for inventions, they must be registration. Plants, variety, if no registration, no protection. Then Professor Woye mentioned confidential information, and he noted that copyright doesn't protect ideas. Share your business idea or proposal. It could be a story for a film. It could be a business idea with a bank, with a big company that you share it in confidence, and they then make use of it without your permission. You may be able to pursue them for breach of confidential information. And I want to tell you that there are laws in Nigeria, and these things have been enforced in Nigeria. Now, you have IP. Let's try and identify various industries and stakeholders, because once we identify them, we've been the law and the principles have been shared by Professor Woye. But who are the people the law is targeting? If we identify them, it may just be that we have a low-hanging fruit around us that we can market ourselves to and say, oh, I can be your lawyer in doing this or that. So you have the big clients, you have those who are not so big, you have financiers, banks, investors in the entertainment and arts industries. You have sports clubs, because those sports clubs, they could have trademarks. Arsenal, all of them have trademarks, and then they have copyright even in their events. Clubs, managers, agents, coaches, regulators, advertising agents, they use music, they use video and other content. So all these are protected by copyright. Photographers and they cover events and so on. Newspaper houses, magazines, literary works, so copyright. Fashion, accessories, the drawing of that earring or that pendant may be new. And if that drawing is registered, then there will be protection. If there is no registration, and it's something that will be produced by mold, replicated industrially, then there's no protection whatsoever. So you need to, you have a role there to advise your clients. Hospitality, clubs, hotels. I mean, hotels use music, hotels run events, the rights to those events, recording companies, recording labels, fine artists, exhibitors, museums, drama for theaters, and those who build set contractors. Build this set, another person then copies my set. Maybe there is a right there. So you may just have such people around you. Film, those who produce films, those who write scripts for films, those who exhibit films, cinema houses, agents. All these are important people. And like I said in my last interaction with the NBA back during the Law Week, NBA must engage those people, because many of them don't have lawyers. Many of them don't seek advice when they are drafting agreements. They just sign. This is important. And also agents to actors, to music people, and so on. Then in some copyright-based, those who develop software, those who develop apps, those young chaps, I don't know which area of Ibadan, Lagos, many of them are around Yaba, they need advice. They don't know what the law is. We as lawyers don't even know what the law is. As this program was going on, I think a couple of days back, the president signed a bill. I'm trying to remember the name of the bill, which amended part of the Patents Act, part of the Trademarks Act, and part of the NOTAP Act. And we don't even know, the implication of some of these things. And so you can imagine that your clients would not know. And most importantly, do you even know who the clients are? Because you may have a guy or a boy who you attend the same school, you attend the same church or mosque, and you don't even know that that's the person that you're supposed to be your spouse. So you don't know the person you see all the time may be potential big clients. So software companies, book publishing companies, artists, sculptors, vendors of these things, and like I said, the investors, the banks are very important because they finance or they're supposed to finance. We know that these days banks don't even give you a cash. So they may not be doing what they're supposed to do, but really, if they do, there's a lot of scope for some of us who act for banks because they are finance some of these activities. So then you also have designers, artists. I think Professor Woye alluded to either a model or a film person, so can you take the photograph of that model and use it in your advert or put it on your website? Can you use a photograph of a sports person or a celebrity? Can you use the music of another person without his permission? So those who design logos that are used for trademarks, they may have rights in them as the authors of those. So what if they have drawn the trademark, created a trademark, and they are not paid for it? I remember one of the very exciting cases I did very earlier on when I was doing my PhD in England was, and my eyes opened wide that, this architect was not paid for, if architectural firm was not paid for development in the Docklands, and the company went bust, and they used architectural copyright to pursue the liquidator. You cannot continue doing this without paying us our fees because you've been infringing copyright. So many companies own trademarks, but many of them don't register the marks. I mean, own in the sense that they use marks and logos. There's hardly any product, I mean, a trademark. Now, many of them don't register. Some register, they don't renew this mark. So research institutions, there's so many around us here in Ibadan, universities, inventors, agricultural institutes, plant and animal breeders. These are people who have, these laws were made for, and they need to understand the law so that they may invest in our services to help them in obtaining our rights and their rights, since a lot of it comes enhanced only by registration. Then companies that may wish to merchandise or endorse celebrities, you want to use somebody's photograph and so on, you need to, they need to know what to do. Some people, I mean, the other day, Who Wants to Be a Millionaire? There was a Nigerian company, multinational, that wanted to do a version of it just for its own staff and businesses and so on. And the question was, can they do that without the permission of the owners of the rights in Who Wants to Be a Millionaire? So those are very, very interesting issues, and we need to understand how this work with relation to the owners and so on of the right. So what are the rules? I mean, the things which lawyers can do, there's a lot. First, identifying the possible right holders, identifying the users. Because some people, I remember in the early days of my career, I remember meeting an old friend of mine who was working for the recording industries internationally. And when I met them in London, she was saying, "But Bankole, you act for artists. So why are you coming to meet us?" And I thought, sorry, I'm a lawyer. I do everything. Or I'm a copyright lawyer. I do everything. But in some parts of the world, you are probably more specialized because you act more for this or for that set of people. But until we build up, it's good to know the low-hanging fruits, identify them, and then be able to approach them with a view to giving services. So what are the services? You can help with negotiating agreements. Many people don't, who own the rights, don't seek legal advice when people want to exploit or seek their license or assign those rights. They need advice for this. Many users, those who want those rights, for instance, I don't want to mention name of some clients who found out that you didn't get a lawyer who knows this area of the law in drafting these agreements. You just took precedents from the internet, like Professor Way alluded to. There is no registration of copyright in Nigeria. Meanwhile, there's registration in the States. And then you take precedents, which is taken from the States. They use the word called work for hire. There's nothing like that in our act. And the implication of work for hire for copyright that is, you are like an employee, work made in the course of employment. The implication for copyright in America may be different from Nigeria. The implication for patent in Nigeria may not be the same in other parts of the world. So understanding this, first of all, understanding the law, so you help even in negotiating. When you're negotiating and you know that, for instance, the Patent Act says that licenses granted should be registered at the Patent Patent Office. Or a license that is granted to a licensee still vests in the licensor the right to exploit the patent and the right to license to third parties. Meanwhile, you want your client who needs to be the owner of the only person exploiting the patent in Nigeria. That means your client needs either an assignment of the right in Nigeria or an exclusive license. That is, I'm having it exclusively. No other person is going to have this right, be able to exploit this right in Nigeria. So, but if you don't know that the law already says that unless there's something to the contrary, generally it will be that the licensor can make use of this right after even licensing you. Then the kind of drafting that you do will not be sufficient for your clients. And that can be problems tomorrow. Many of us in Nigeria have not been sued for professional negligence. Maybe that's why in other climes, like, look, this is what I wanted, but that is not what you got for me, So drafting non-disclosure agreements. So Professor Woye mentioned this. This is an agreement that when you are sharing some business proposal, it could be even a story, could be an event with third parties. You say they should sign a non-disclosure. That is, they will not non-circumvention. They will not go behind you and exploit it. They will not also disclose it to other people or make use of it. So drafting those kind of agreements, drafting licenses, drafting assignments, helping, like I said, even to negotiate when payment is made. And he mentioned the fact that rights don't last forever. Copyright may be 70 years plus the life of the author. So do they need the right for all the 70 years, or they just need it for 5 years? So look, all you want is for that event. We'll give it to you for 1 year or for 2 years. It reverts to us, just like land can be mortgaged or leased, and it reverts to the owner of the land. So Acting as in-house counsel. I remember a friend of mine, we did the masters together in 88, in 87, 88 in Unilag. And I was surprised around 1990 that he got a job as in-house counsel for a publishing firm here in Ibadan. And the reason was because that publishing firm had been sued in one or two cases that I was involved in. And so they just realized that, look, we need an in-house lawyer handling all this matter. So I've highlighted, or those related, I'll think about some a job even as in-house. Now, of course, representing clients in courts, a lot of this situations, some of which Professor also referred to. I mean, the cases between this person who took this who may have taken part of somebody's to help institute. I remember when we got an order a little over a year. The question is, Master, NTA says we are the owners. The estate of Ambassador Lushola said, we are the owners. We created it. Oh, you created it, but you created it in the course of employment. Therefore, it belongs to NTA. And very interesting issues, which lawyers can help to ventilate in court. And also enforcing these rights. Sometimes you need to go to the streets to enforce, because there's a lot of piracy or counterfeiting. Sometimes it can be very dangerous because the people who do those things. Some years back, the Copyright Commission struck at Alaba, and the Alaba people fought back with guns and burnt several cars of the Copyright Commission. So it can be very nasty thing if you don't know what to do, because the law on the streets is different from the law. I mean, on the law in the book may be different from the law on the streets in terms of enforcement, getting the police to even assist you in enforcing court orders. Okay, so you can also represent clients in arbitration and ADR disputes. One of the reported cases, the Court of Appeal that arose from Benin High Court was an arbitration of a book publishing agreement. And so the lots that happen in that mediation, arbitration and other ADR, you can also act, apart from being the lawyer to one of the parties in dispute, if there's an arbitration clause, you can also act as a mediator. It can be a very interesting and rewarding experience acting as mediator, neutral, as experts. Because if you're an expert, sometimes some people say, look, there's a dispute, but can we have somebody like you give us an expert opinion on this? Because that will help us in our negotiations to know who owns the right, or whether there's any right. For instance, the one Professor Ware said between the lady who had a film and somebody who said, oh, this was derived from my book. Maybe just the people coming together and getting an advice of Professor Ware, for instance, or one of you, if you've done your homework well, may just help to put that matter at rest. And it's been fun doing things like this, acting in all these capacities. So these things are possible. Then, of course, registering, renewing, maintaining a trademark, registering the patents, obtaining the patents, renewing it annually, registering the design and renewing it every 5 years until it lapses, registering now the new law, plant variety protection, because there may not be as many Nigerian companies that are active in plant variety yet, but they're going to be foreign companies. So registering this can be interesting work. So also for registering trademarks, you have foreign owners of rights. You have local owners of rights. And there was a time when, if you check before we set up the Intellectual Property Law Association of Nigeria in 94. Before that, I said that, there were more years. The local ones have grown because, I mean, a company that does what's it called? That does food, beverages, or cosmetics, and has a few products. You find out that it registered a company, but then registered several trademarks, sometimes registered several patents, you know. So this can be interesting work for us to do. Another thing lawyers can do is lobby for law reform, lobby for policy reform. Like I said, just as I was about to start speaking, the new law that was passed in the last couple of days, for instance, by the president, was aimed at ease of doing business, but it also amended several laws, including the Trademarks Act, for instance. One of the changes made to the main change made to the Trademarks Act is that it defines goods to include services. I mean, that is something which some years back, I was involved in drafting a regulation that tried to expanded the definition of goods to include services. And some people said, oh, that is still not proper, in the sense that you can't use a regulation to amend a law. But that's how many people have been able to register services as marks, even lawyers. What we do is not, we don't sell goods, we sell services, you know. So then also drafting regulations, statutes, and policies. Some of us have been involved in, I mean, the franchise bill, which has been passed by the Senate. I was involved in pushing and drafting that, involved in several policies and so on. And even some people are saying, oh, we can even introduce ADR to trademark practice. And some years back, some of us drafted some regulations, but that did not really come through because we didn't have enough in terms of push. So lobbying and so on. Sometimes lobbying can pay, in the sense that somebody pays for all this work, but many other times nobody pays. So, but the fact is, if nobody pays you, eventually, and you are able to just struggle and push yourself, you establish yourself, and work comes eventually to pay. So it's like doing pro bono work, which clients and stakeholders is very important. Because when you educate them about the lapses in their systems, when you educate them about the implications of new laws, about the implications of new decision that's just been handed over. One of the points I think Professor Woye made is that when you draft, there should be a contract. In the contract of employment or any other contract, you should indicate that the owner of copyright will be the employer. Some years back, we were litigating a matter which the one young guy who had never traveled before in his life was trained by his company, sent to many countries, and he was able to do, they were able to do some software which he sued, which he left the company and then he licensed to several banks. And his boss was mad and sued him. But his boss lost because there was no contract transferring the copyright ownership from the employee, who the law says is the owner, to the employer. So drafting this, educating them and say, do you know that this is the implication of that provision of the law? You need to do something about it. That is the kind of education we're talking about. So educating clients, educating stakeholders can bring about opportunities. Now, it's also possible that you also evaluate works, audit intellectual property and evaluate them. Audit in the sense that many of them don't realize that they have not been renewing their licenses, that maybe their rights have expired or maybe about to expire and so on, you know. So, so lawyers can also work for businesses that rely on IP. meaning entertainment industry or sports industry, a lot of lawyers get involved. We buy up a company, and like Chocolicity Nigeria is owned by partly owned by some lawyers, and they made so much money promoting the business of music. They do some work from that business of music, but the business of music itself brings them good money. So it's possible for you. I have a case scenario that my time is running that says, if you, for instance, a client of yours invents a compound in soap that also acts as an antiperspirant, you may be able to obtain a patent for such a person, and then license it to the company, register the trademark, and assist the company in filing for and enforcing its rights, and also earn revenue as a shareholder. So what do you do as lawyers? You must know the law, which is why I must thank Dr. Adibimbola and the chair of MBA for this, stakeholders, and try and get work, sometimes from the big boys or from the House of Commons. Become visible by speaking, by writing, by just moving around, joining us sometimes, and then even writing on the internet or social media. Sometimes there's a debate. People are saying something, oh, this has happened. Can this person has taken this other person's music or using a similar name, and they are debating. You could just enlighten them. Now, if you enlighten them, it's like free, but at least you're making a name. Then there'll be referrals. And finally, what I do, I pray. And that helps. And I think on that note, I know my time is almost up. Let me stop so that we can have a robust time of questions. And I know Professor Owoye is in Australia. It's almost his bedtime. I'll stop there. Thank you very much.
Thank you very much, Professor Bankole Sodipo, Senior Advocate of Nigeria, for the very insightful session. I really enjoyed the session, and I'm very sure every other participant on this call enjoyed the session. So Professor Sodipo SAN has given us an in-depth knowledge into the roles and opportunities for lawyers in IP. So moving on, we will quickly move to the question and answer session. However, we have two questions already from Bumi Eyalade Esquire, and I believe the question is for Professor Owoye. So I will quickly read out the question, sir. Sir, can you still hear me?
Yes, I can. Thank you.
Okay, sir. Thank you, sir. So the first question goes to you, sir, and the person is asking, I would like you to kindly shed light on service for hire with regards to copyright. Say, for instance, I pay a photographer to take my picture. Who owns the copyright in the pictures taken, including the negatives and the soft copy? That's the first question, sir.
Do you want me to take that first?
Yes, sir.
Straight away?
Yes, sir.
Thank you. I think Professor Sodipo SAN already answered that in his presentation. Essentially, when you have a service contract or you employ someone to work and they create a work, they create a copyright work in the course of the employment. Interestingly, under Nigerian law, the work belongs to the author. Section 9 of the Copyright Act. And that is why for every employer or anyone commissioning a work, you need to, if you really want to keep the copyright in your work or in the work generated in the course of your employment, you need to include an intellectual property clause in your employment contract. Now, this is actually a little bit of a sensitive topic because a lot of people, when they invite photographers for personal events, they want to control their photos. They want to control, because these are personal, maybe it's a very private ceremony and you've gotten a professional to come and cover it. And it's more important for celebrities and people that are very popular, whose photos and family affiliations may be things of public interest. So the way to do that is to ensure you have an agreement in place for the photographer to deliver everything to you, if you want to retain those items and if you want to have copyright in them. If you don't do that, the photographer has the copyright, and if your images are so valuable, they can begin to trade with your images, sell, do whatever they want. But if you don't want that to happen, and for most Nigerians, they probably don't care because nobody is going to sell their pictures anyway. But there are celebrities who would care. Under the Copyright Act of Australia, for instance, there is actually a provision in the law that says that when photographers cover family events, they do not own the copyright in those photographs. But we do not have an equivalent provision in Nigeria. So, the Nigerian law does not have that sort of provision where family events are protected and photographers don't have yes, the photographer will have the copyright in the absence of an agreement to the contrary. Section 9, Copyright Act.
Thank you very much, sir. Going on to the second question, the same person asks, as regards the territorial nature of IP, will copyright protect my published book that is adapted into a movie outside of Nigeria? Say my book was published in Nigeria.
Thank you for that. There is a reciprocity arrangement under the international conventions for copyright, particularly the Bonn Convention. So when a country is a party to the Bonn Convention, as it is with most countries of the world, I believe, I think most of the countries in the world today are now part of the Bonn Convention. So that's not likely to be a big problem when you are dealing with countries that are not those that just basically became independent states in recent years. So as long as they are parties to the Bonn Convention, there is a reciprocity arrangement. So even though it is published in Nigeria, that protection will apply in every Bonn Convention country without the need for registration. So all the person will have to show is to basically establish that they own that copyright in the work and there has been an adaptation, and they can pursue an action in any country where the right has been violated. Of course, there could be financial constraint that may make it difficult for some people to take matters up. But the thing with intellectual property, just like Professor Shodipo said again, is you must be ready to enforce rights if you want to assert your rights. Nobody will enforce your right for you. So if you think there is a violation and you want a redress or remedy, then you must be ready to take the necessary action to seek the redress. A lot of Nigerian firms work with foreign firms. In a situation where that happens, they can actually liaise with a foreign firm to make sure an action is taken in the overseas jurisdiction where the infringement is taking place.
Yeah, if I may add to that, I mean, what Professor Way just said, certainly there are cases that people have litigated in Nigeria for infringements that have been done in on the internet, infringements done in other parts of Nigeria, of the world. Similarly, for infringements done in other parts of the world of Nigerian works because of this reciprocal arrangements. So even though there's no registration of copyright, if it's copyright, you can, because of this reciprocal agreement, you can sue. But if it's a patent, if it is a trademark, then there may be issues because those ones, they are protected after registration. And if you don't register in those countries, you may not then be able to enforce any right.
Yes, thank you very much. So that's a very important addition. Yes, those requiring registration, that's where the territorial limitation is really more powerful. You don't register, you don't get a right, and you can't enforce. Yes.
Thank you very much, sir. Thank you very much, sir. So we would now go to the next question. Oluwabusola Oluwani asked a question, and please, I would like to direct this question to Professor Bankole Sodipo FAN. Please, is there a protection for me under the law of intellectual property if my life experience is made into a movie?
Very interesting question. If you're, I think Professor Woye mentioned that there's one of the requirements for literary copyright is that it must be fixed. Musical copyright must be fixed. Artistic works must be fixed. But sound recordings, usually, I mean, films are also fixed before you can call them a sound recording of film. Now, so you have your very interesting life story. If it is written as a, if you have written it as a book, or not even published it, but you have excerpts in your own handwriting, for instance, and somebody makes use of that. One of the bundles of rights for copyright owners is the right to make a film in a book. The copyright includes the right to make a film of the book. So anyone who does that will be infringing your rights. However, if somebody does independent research about your life, and based on the independent research, they then publish some parts of your life, then they are the owners of the copyright in the work that they have done, the literary work, which is the underlying work for making the film. But it may be possible that you may be able to stop some people from publishing some parts of your life, which may be like an invasion of your privacy. The Constitution, Section 37, protects, grants the right to privacy. And so if you're able to couch your claim on that, oh, this is a breach of your privacy. Say, for instance, somebody has some medical issues, and then it's part of what they now put in the film. Now, how did they get to know? They breach the doctor-patient privilege by stealing that information from the hospital or whatever. You may be able to stop that aspect of it. I think I'll stop there. I don't know whether Professor.
Yes, thank you very much, sir, for that. And I think Professor Sodipo already mentioned the fact that you cannot have a copyright protection in such cases, and that is absolutely the case. If someone has made a story from your life experience, you don't have any copyright there. They because they've done their work and it's their copyright. Now, I think it's a tricky situation to actually find a redress, but it is still possible. Now, it will depend on the circumstances. If the story is being told about a very popular person or is well known, a celebrity's image is valuable, and they may be able to make a claim in the thought of character merchandising. That's another form of intellectual property. But that will only apply to people that are famous, not every individual. So if someone is famous and their own existence, their image commands commercial value, and someone is making a story about them without their consent, without signing an agreement with them, then it is possible for them to actually take an action and say that there is a case of character merchandising, they are profiting from their image. And that can be one remedy, but that is not a remedy available for every person. Now, if someone is not in the level of celebrities or famous people, just an ordinary individual, what may still be possible, again, it's not going to be so straightforward, but there is the possibility of making a case on privacy and raising an action in the thought of confidential information. They can argue that the story intrudes into a number of confidential issues relating to their life without their consent, and then you need to begin to establish those elements that there is an obligation of confidence. It is possible. It could be really tough to prove it and establish that, but yes, it is a right that can be explored. I will say, as a matter of advice, that if you're advising a party who wants to do that as a lawyer, it is safe to get the consent of the person whose story is being told, to avoid actions based on breach of privacy for people that are not that famous. And if you are dealing with a famous figure, definitely you are looking at more than just privacy. They can even say you are trying to profit from their image and raise character merchandising point. But certainly there will be no copyright argument there. So that's my response to that. If there are other questions.
Thank you very much, sir. Dr. Yemisi Abimbola has a question. Please unmute yourself and ask your question, ma'am.
Thank you very much, Mercy. First of all, I want to appreciate the speakers for this very enlightening discussion. I mean, my eyes have opened into so many areas in IP that I thought I knew so much about. I really appreciate you for all that you have taught us already in this very short time. And my question is not, I'm not sure if it is purely IP, but it was triggered by something that Professor Weye said. You know, when he said it is not copyright if you take a portion of a book or you get a story and you formulate it in your own manner and things like that. So I just thought of asking this question. That's why I couldn't write it on the chat, because the way I want to say it may not necessarily be very straight. Concerning the issues of plagiarism, for instance, thank God that both speakers are professors. So when it comes to plagiarism, there's this software that is usually used, and they go ahead and the software would still say your work is plagiarized because you use somebody's work. Even if you acknowledge the work very well, you referenced it, and it still goes on to say you plagiarize, and then the percentage goes up, and then they reject your paper and say because of plagiarism. So I want to ask, my question is, what is the thin line? Because if I can take somebody's work, formulate it in my own way, and it's not copyright, then why is it that the other side, if I do that for another one, it's termed plagiarism? And even some of the general words that everybody uses, like maybe rights to life or fundamental human rights, constitution, African charter, discrimination clauses, it's termed plagiarism because you used it in your work. So I just want a better explanation on the issue of copyright and plagiarism, if it's relevant. Thank you.
I'm happy to take that if Professor Shudikwesen gives me the go ahead to do so. Yes, so thank you, sir. Yes, so essentially, it's an interesting question, Dr. Abimbola. It's a question, it's actually something I've mentioned in my IP sessions with students at different points. And I always emphasize the fact that there is a real difference. Though there are similarities, there are linking areas, but there is a big difference between plagiarism and copyright infringement. Now, a lot of things may be considered plagiarism without being an infringement of copyright. Take, for instance, when people, even in substantial copying, which wouldn't amount to copyright infringement in copyright law, would become plagiarism. So, and plagiarism is so wide that for academics, we know that even taking an idea from an author without citing that author is considered plagiarism. So it's not copyright infringement. We already know that ideas are not protected by copyright. So if you change the expression, it's not copyright infringement. Plagiarism softwares might not even pick those ones, but if people find out that, okay, these ideas have been taken from a particular work without those works being cited, it will be considered as plagiarism, even though it's not copyright infringement. So there is definitely a big difference between the two. And plagiarism is wider in its scope than copyright infringement. You can have situations where people are said to have plagiarized without actually having any copyright infringement. Now, I think there is a problem a lot of people don't appreciate about Turnitin and other so-called plagiarism softwares. As a matter of fact, those softwares don't detect plagiarism. What they do is to detect similarity, but people don't understand that. A lot of people, even some academics, don't understand that. I've seen academics who would say, oh, 60% similarity, plagiarism. No, it is 60% similarity and not 60% plagiarism. Now, what you look at is the software, Turnitin, for instance, will pick every similarity, including the ones that you have quoted, including the ones that you have quoted, just like you said, man. The ones that have been quoted, it will put them in the percentage of similarity. Now, quoted words that are duly referenced, there is no plagiarism in that. You've already quoted it, you've cited the source, but Turnitin will highlight it because it is similar. There is the similarity. It's taken from somewhere, but you've actually done the right as an academic by putting it in quotations, putting the sources. So at the end of the day, when looking at those reports, you look at what has been highlighted as similar. So if footnotes have been taken, references used in another work, you don't count them as plagiarism. Okay, those are footnotes and references. The two authors have used similar references. That's not plagiarism. Okay, there are sentences that look alike, but the author has quoted in the proper way and applied the right quotation marks. That wouldn't be plagiarism. That would be plagiarism where the author has copied verbatim without any citation or without quoting them. Then that would be plagiarism. But let us not make the mistake of assuming that every similarity is plagiarism. Similarity is what it is. It is similarity. The question is, have the standard academic practice, as the author used the standard practice in referencing works and citing authorities and using quotation marks as necessary? So if all of that was done in the highlighted pieces of similarity, then you are not infringing copyright because you've really cited the source, and you are also not committing plagiarism. And we also know even that generally research works come under fair use exception. So the likelihood of anyone even being taken up for copyright infringement based on research work is very low, because you can actually argue criticism and fair use on that point, even if there were issues of copyright involved. But plagiarism, like I said, is wider than copyright. And once you have used all those marks, you've quoted appropriately, cited appropriately, it's similar, yes, but it's not plagiarism. But if those words are copied verbatim without quotation marks or references, then that is plagiarism. So it will be for the academic to look at what has been done to determine whether it is plagiarism or not. The software will not tell that difference. Yeah.
Thank you, sir.
Let me just add one more point. I mean, because like Prof has said, um, they all appear to be the same thing, but they're not. That is copyright infringement and plagiarism. Copyright, like he said, does not last forever. And there may be a case where somebody steals another person's work that has expired. You cannot sue for copyright infringement because copyright has expired. It's fallen to public domain. That's the word we use. But if you do that as plagiarism, because you've just taken the thing as if it's yours. Subtle differences here and there. Let me just stop there.
Yes, I think there is also a question from someone about if
Yes,
more
yeah.
than one person, if more than one person could own copyright in a book, certainly yes, you can have co-authors. And the ISBN registration, that is used more for database purposes. Your copyright protection is not dependent on the ISBN registration. You have copyrights even in works that are not published. If you have a manuscript that is just in your handwriting at home, it's protected by copyright. But the ISBN is good for referencing and database and record purposes. And generally, when you want to put the work out internationally, they will actually value it more because it has the ISBN, it can be traced.
Thank you very much, sir. We still have one more question in the chat box. But before I read that, Bumi Eyalade has been raising her hand for quite some minutes now. Please unmute yourself and ask your question.
Thank you. I really appreciate you.
Sorry, I had to mute you because we can't hear anything. We could just hear noise from your side. So I will mute you again and see if you can still ask your question. Just try again. You can unmute yourself now.
Hear me now?
Wow. Yes, we can hear you now. It's a bit better.
Okay. Thank you very much. Thank you. Thank you to the two professors. I really appreciate. I asked a question earlier, which was brilliantly answered. There's a follow-up to that. I'm talking about a situation where a book published in Nigeria is used as well. And there was the answer about the Bonn Convention covering that. So I would like to know in that situation, what country would, okay, say I'm looking at Nigeria and Ghana, what country would have jurisdiction to hear such case?
So
Hello?
generally, yes, generally the action would be taken where the infringement has occurred. That's the general practice. So if infringement has occurred in Ghana, for instance, that will be the right place to take the action. Yeah, that would be the right place to take the action where the infringement has occurred. Yeah.
Thank you very much, sir. I appreciate that.
Of course, my very learned senior in the field and who is much more experienced in practice, the learned say can also say something about that because I'm sure he would be familiar with a lot of these things in real application.
Yeah, I remember some years back, we had a matter where there was an infringement in England in the sense that somebody's film was dubbed in by the owner of a studio in Lagos and taken to London and licensed in England, and it was reproduced in England. And the defendants said that the infringement occurred in England, and we were able to show that the dubbing of that film makes it was an exercise of the right to reproduce it in Nigeria. So that was the foundation for an action in Nigeria. But however, in this day and age where there's a lot of infringements, even on the internet, it then can be argued that there is also infringement in Nigeria, even though maybe the film was or music was produced, reproduced, and distributed in Ghana, but people can access it in Nigeria. That means that there is some effect. And the best way I'd like you to follow this or dissect it as lawyers is we're all used to criminal proceedings where an action a criminal action starts in one part of Nigeria and is completed in another part of Nigeria. It may be possible in some situations to sue in any of the places where part of the act was done. So that's the best way, because we can't give an answer for all situations.
Thank you very much, sir. Thank you very much. We have 2 more questions on the chat box. And with those 2 questions, we would round up, and then we would have the chairman of the MBA Ibadan branch to take the vote of thanks. So let me quickly read out the 2 questions. The first question is, I don't know if I should call this a question. 1 minute, please. What are the steps a young lawyer who reside in Ibadan can take to be exposed to the first-hand experience in intellectual property, bearing in mind that intellectual property is not really rampant in Ibadan?
If Prof will allow me, intellectual property, my first intellectual property clients are from Ibadan. So there's a lot. Ibadan is the what's it called, capital of book publishing in Nigeria. I don't know whether that has changed, but it was. So then there's a lot of art, music, even in Ibadan, film, dance, theater, and then a lot of products also are headquartered here that people can may infringe the rights, So that's why I try to identify who the law seeks to protect, the industries, the stakeholders, and what you need to do is just follow that pattern in identifying them, and then try to sometimes you need to knock several times. Some people knock once and the door is open, but sometimes you knock several times, people don't open, and later they may open, they may not open, just keep knocking. And that's why I said I also pray.
Thank you very much, sir. The last question for this session is from Boluwati Fesoya. Does the moral right in copyright also expire?
Well, okay.
So
Please go on side. I think you were already taking that question.
Professor,
okay,
you can answer that.
All right, thank you, sir. I'll go on. So the moral rights involves the right of attribution, and I think if you followed Professor Chodikpo's answers to earlier questions. He already mentioned the fact that with plagiarism, even if the copyright has expired, you still have to acknowledge the author in work citing that particular piece. So that is what moral right is, acknowledging the source, acknowledging the author in dealing with the work. And even if the copyright has expired, the moral right would still subsist. So the right not to damage the work, or the right to have the author acknowledged in every reference to the work. Yes, so it doesn't expire, really. As long as you are citing that work, the right of attribution is always expected to be maintained.
Thank you very much, sir.
I think there was someone who was actually raising their hand.
Yes, I can still see the hand. Abayomi Apata, you will be the last person to ask question for this session. So please unmute yourself and ask your question. Thank you.
Thank you very much, Madam Moderator. First of all, I want to appreciate our lecturer, Professor Oweye, and the learned CEO. Just indulge me a little. Myself and Professor Oweye were on the ESCO of LSS in the University of Ibadan when we invited the then Dr. Shodipo to come and lecture us on intellectual property. And coincidentally, both of them are now professors, and they are here doing justice to the topic. It's good to see you, Sam, Professor Oweye. Now, my observation is that I want to diversify my practice in Lagos, and therefore I started delving into intellectual property, and it was difficult for me to get clients to come in. What I decided to do is to look into the entertainment industry in Nigeria, and I began to offer pro bono services to up-and-coming artists. And I discovered that we don't have a standard Nigerian contract regulating that space. Most of the time, you see record labels copying an American contract, and some of the terms of that contract are not enforceable in this client. And again, a lot of international record labels are coming to Nigeria to harvest our talents. They give them any paper, and most of the Nigerian lawyers that they consult don't even have any knowledge. They just read those contracts with the eye of a purely commercial law practitioner. Will I call it a question or observation, is that intellectuals like the two professors we have should be able to help with literature that will give us a standard contractual template, which Nigerian practitioners can use in order for the contractual rights of our clients, the musicians now, or the local entrepreneurs in the entertainment industry, to help. Because if you want to go to our courts, and most of the things that in the American contract, okay, I'm sorry, for instance, I was watching an interview of an artist called Brimo, and somebody asked him a question that he breached his contract with Chocolate City. And that's Brimo's defense. The contract they gave me is an American contract. It can't be enforced in Nigeria, and therefore I had to walk away. So it's like a question and a plea for intellectuals like Professor Oweye and Professor Shodipo saying to help us develop a contractual template which we can adapt and begin to help grow our entertainment industry, because the exploitation in that space is too much. Thank you very much. I would like something from Professor Oweye and Professor Shodipo on that. Thank you very much.
Thank you. Thank you, Mr. Akpata. And it's interesting to hear about those UI days again as well. Yes. I think I would just say that Professor Shodipo is one of those that have actually been doing a lot in advancing the development of the field in Nigeria. And I know he is involved in a recent work on policy formulation for IP in Nigeria with the World Intellectual Property Organization. So he's actually the best placed expert to take that question. So I would defer to Professor Shodipo saying on that.
Well, I'm not sure that she's the best to answer that. You know, there are too many problems. Too many problems. Somebody came into a city in Africa, or let me say village, and they said, oh, they don't wear shoes. And said, that means I cannot sell shoes. But another person said, oh, that means there's opportunity to sell shoes. So there are problems in the industry. Part of the things lawyers don't do is come together to see how do we use our lawyering skills to improve our own space here, so that these musicians will seek legal advice. Most of them don't seek legal advice. They prefer to pay money to their agents and maybe police than to pay lawyers. And even for some of those people, young companies, unless you sign contracts that are tight, that they cannot leave you when they become big, you find out that they want to leave. And for me, I don't like, those kind of contracts, because like, if you are nothing and I've helped you, I just want to trust that if you appreciate me, and if you don't appreciate me, just go. But if you don't tie them, they just want to leave. Now, the Copyright Commission some years back did what you could call model contracts. If you go to their website, they may be there, but if you ask, write them, they may be able to send this. But you know, the danger of model contracts too is like landlord and tenant agreement. We draft one and then everybody uses it, lawyers will not be paid. And then every landlord and tenant situation may not be the same. You know, so those are the dangers in terms of model contracts. But I agree with you. There's a lot of terrible things happening out there in terms of the standard forms that people use. And it's because there's not been much litigation that has gone to trial for the courts to actually hold that this contract was this, or annul it, or it's no effect, and so on. Until those things happen, maybe some people will not learn. But I hear you. There should be workings, either Intellectual Property Law Association of Nigeria, section of business law of NBA, in terms of trying to draft model agreements. But like I said, once they are drafted, you find out some people will just use those things. They won't even come to lawyers. So that's why I said there's a lot we need to talk about. So I want to thank the chairman, Mrs. Aladeni Folashade, because this is a very important thing. And you'll be amazed the number of employments that the software industry, the film, the music, sports, and so on has and can have in Nigeria. The amount of innovation that's going on, and people don't have protection for their rights. So there's a lot of work and scope for us as lawyers. Albeit some of it, there may not be more money or much money to start in. And somebody says, I want to diversify. That means you want money, not that you want to start investing money before you make more money. You know, so those are issues. And thank you for the opportunity today.
Thank you very much, sir. I will now hand over to the NBA chairman, Ibadan branch, Mrs. Folashade Aladeni, for the vote of thanks. Thank you very much, ma'am.
Thank you so much, Mercy. I want on behalf of the Nigerian Bar Association, Ibadan branch, we hereby express our deepest appreciation to Professor Bankole Shodipo, Senior Advocate of Nigeria, Professor Lashipo Uweye, for this insightful session. The session has been so enlightening. And I remember Professor Shodipo always telling us to start from the low-hanging fruits. So for us in Ibadan here, there are low-hanging fruits in the publishing sector, in the universities, in our institutes of agriculture. So let's start from there. Maybe we can build a chocolate city in MBA Ibadan. I want to thank you so much to the participants, to the CLE committee of Ibadan branch headed by Dr. Yemisi Abimbola, and all the team who worked behind the scene to bring us this very, very insightful session on IP. We've learned so much, not just IP. We've learned that IP can lead as a relationship with thoughts, the law of thoughts, contract, employment, and so many things. We can't thank you enough, profs. We are very grateful. Thank you to all the participants. The questions have been wonderful. The question on my life, can I have rights in my life? Can it be protected? That was very interesting. Thank you so much, profs. We appreciate you and wish you well in your future endeavors. Thank you so much. Mercy, I'm done. Hello.
Yes, ma'am, still here, ma'am. With this, we've come to the end of the session. Thank you so much, Mrs. Aladini, for the vote of thanks. Thanks to our speakers. Thanks to participants who have stayed till the end. We are very grateful. So we'll see you again. Bye for now.
Hi.